NACDL is the association of the nation's criminal defense bar.
The human brain, every decision that a fact finder makes about your case is made here. If it's a judge deciding to grant your motion to suppress, if it's a jury deciding whether or not to acquit your client, if it is a police officer deciding whether or not to make an arrest. All decisions about our cases are made inside our brains. And we can't even begin to understand how to persuade jurors and judges until we understand the way the human brain works and we figure out how we can apply that in our cases on behalf of our clients. So how do we make decisions? Cool.
Every day, we make hundreds of decisions. We think we're in control of what we do. But are we? Okay, it doesn't matter if you choose left or right. So how do you decide?
So how do we decide? How do people make decisions? Well, whenever we are called upon to make a decision, there are two parts of our brain that are sort of working in concert. One is the deliberative system, the other is the intuitive system. And the intuitive system, like it sounds, is the part that acts on instinct, intuition, more commonly known as our gut. The deliberative side, again, as it sounds, is the side that reasons, that thinks through things and thinks things in a more complex and careful way. The scary part is that 95% of the 10,000 decisions that we make every day are made in our guts without any deliberation at all. And about 79 to 93% of those gut decisions are made based on just our personal experiences, the way we grew up, and our social perception. And this is evolutionary, right? And there's a couple of reasons our brains work this way. One is for survival. Basic survival instincts do not give you time to decide whether this thing is going to eat me before you run away, right? Another reason our brains do this is to stop what's called cognitive overload. Our brains are capable of processing every single blade of grass when we look at a lawn. But if our brains did that every day, they'd explode. It would be too much information. So our brain makes a shortcut and it looks at all those individual blades of grass and processes that as lawn. And when we do this in the context of decision making, it's referred to as heuristics. And what that means is we recognize as human beings patterns, and we recognize things based on the way we grew up and our social perceptions, and we make decisions without thinking at all. And this is not a presentation about bias and implicit bias, but if you go to presentations about implicit bias or look into the psychology of bias, we'll see that these shortcuts are often at the core of at least implicit bias in decision making. And it's just a way for our brains to process lots of information without overloading. Now, some of you may have seen diagrams like this before or read Daniel Kahneman's book, Thinking Fast and Slow, right? And said, I've seen this, I know this. In the last 10 years or so, I will tell you that the research has changed a little bit when we talk about system 1 and system 2 processing, the deliberative and the intuitive. We sometimes think of these things as two separate parts of the brain, and they're really not. Scientists today, or psychologists today, recognize that these two systems really kind of work in concert. And when we think about emotion, right, we heard a wonderful lecture about storytelling. and talking about the emotion and the importance of bringing our audience in with emotion. Today, the prevailing view is that there aren't these two separate systems, but that emotion aids cognition. If we have an emotional feeling, a gut feeling about something, it's going to make it easier for our brains to cognitively process it. So that's kind of what we're going to talk about today. You may be asking yourselves, what does this have to do with lawyering, with being a lawyer? It has everything to do with being a lawyer, because we have to understand how our fact finders are going to make decisions, how their brains are actually working, so we can use ours, not only tell good stories, but hopefully use some of the techniques that the brain science can teach us to make those stories aid juror and judge cognition.
Okay, it doesn't matter if you choose left or right. So how do you decide? The research we do here shows that our decisions and our actions are influenced by things that we don't even see. We asked our participants to follow a simple instruction: press left or press right, and then rate how much control they felt over the outcome of that action. During the experiment, we used these electrodes on the scalp to measure the tiny electrical potentials generated by the brain. But we also showed an unseen cue, which we call a prime, just before the instruction to press left or press right appeared. Did you see that? Watch again. Sometimes the prime is helpful, so your brain is prepared for the correct action. But sometimes the prime is misleading, so it was harder to press the correct key because the prime made your brain start to prepare the incorrect action. Sometimes the prime can even cause you to make a complete mistake.
But here's the paradox. Our participants said that they felt more in control of what they were doing when the subliminal message from the prime helped them to respond correctly.
So it seems that we feel more in control when we're actually being told what to do by a message that we don't even see. Where's the free will in that?
And am I really ever in control of my own actions?
This is everything that we want to do as criminal defense lawyers, right? We want our jurors or our judge to feel empowered to make the decision that we want them to make without telling them what to do and making them feel like it was their idea, right? So how can we use this as we tell our stories? And as I said earlier, this is not a presentation about storytelling. There is a whole other area of brain science that talks about what stories do to our brains, how stories affect our brains. And we touched on some of that this morning. And I suspect that over the next couple of days, you are going to hear more about that specific type of brain research. And I know that Keith Belzer is presenting later this afternoon. You're in for a real treat. He was one of the first people to talk about storytelling in criminal defense. So you're going to hear a lot of that. What I'm talking about is slightly different. What I'm talking about happens before you even put pen to paper to start brainstorming your story. What I'm talking about is identifying who your audience is, asking yourselves, how does that audience make decisions? How does their brain work? What can the research tell us about how their brain works? And what are going to be the barriers to communicating with that audience? And then starting to brainstorm and craft a story that not only is emotionally compelling and visual and all the things we heard about this morning, but it also aids the cognitive process. I'm talking about being the prime, right? Becoming the prime in either your written or oral advocacy. So how do we do that? All right, so this whole thing was born out of and I'm sure all of you kind of operate like this, where you find the interesting thing and you put it on your desk somewhere. And you say, I'm going to do something with that someday, right? So a couple of years ago, I started looking at studies about how people make decisions, specifically about credibility, and studies about how judges' brains work and judges make decisions. A lot of this research is coming out of Vanderbilt University, a gentleman named Chris Guthrie, who's kind of like, I have like a secret nerd crush on him. I've never met him, but he's doing all this amazing research with judges on how their brains work. So I would collect these Guthrie studies and other studies, and I put them in this giant pile, and the pile of stuff was getting bigger and bigger. And then Deja Vishny, one of the co-chairs, called me about 9 months ago, and she said, we're doing this thing on persuasion. You speak. And I said, I would be honored. I'd love to. What is it about? Persuasion. And I said, oh, I can finally do something with the stack of stuff. And that stack of stuff was about 30, actually it's closer to 40. There's 26 identified in your materials, but 30 studies about the brain. And these include studies about decision-making and how judges and jurors make decisions, studies about how we induce empathy from the hearer of our stories, studies about the impact of written materials, unconscious bias in decision-making, even studies about police psychology and how police are trained to make decisions. And then I had to read that stack of stuff. Now, I will tell you that there is no photograph or video of me actually reading this stuff, but I wanted to just show you something that approximates how I felt as I was reading all this stuff, and this is about it. Right? It's like you're reading it and it's like boring, and I feel uneasy because it's not my territory. It's about brains, it's about statistics. There were lots of math. I was like, there's not supposed to be formulas in here, right? There's all sorts of things. And to be honest, some of it was really useful to our work, and some of it was not. So I'm just here to tell you that I did all of this for you. I read all these studies for you. And we're going to talk about some of the studies. We're going to talk about the findings of some of the studies. I've cited some of them in here. All of the ones that I really relied on for the presentation are cited in your materials. And if they're not cited in their materials, and I found it more recently, it's cited in the presentation. So you can do this if you want, but you don't have to. All right. So the studies sort of break down into 4 areas that I think are relevant to our work. One is, how do judges think? What can we learn from the research about how a judge sitting on the bench with you in front of them arguing something, or you submitting something in writing, how do they think? How do juries think? And is it any different from the way judges think? How do police officers think, and how do people think about police officers? And then the other area is, how do jurors think about expert witnesses? And quite frankly, this may seem like an outlier, and it is, because the research regarding expert testimony is a little wonky. And it's a little different from some of the other 3 areas. So I just have a couple quick notes on expert testimony for you. But let's start by talking about our friends in the jury box. And I'm going to start by asking you guys a question. A bat and a ball cost $1.10. The bat costs $1 more than the ball. How much does the ball cost? Tell me. 10 cents, 10 cents, 10 cents. I'm hearing 10 cents everywhere. Okay. All right. So the actual answer is 5 cents. And I put you on the spot by asking you quickly. The actual answer is 5 cents. But most of you, how many of you who said 5 cents actually thought 10 cents first and then sort of processed it? Okay. So the actual amount is 5 cents because the ball costs 5 cents, the bat costs $1 more, making it $1.05. Together it's $1.10, right? So now we're like, oh, okay, we get it. But our brain just wanted to say 10 cents. And if you didn't know that this was about brain science, and you didn't know I was giving you a brain test, all of you 10 censors, myself included, would have said 10 cents, moved on, and never given it a second thought. This is one question on something called a cognitive reflection test. And cognitive reflection tests are designed to figure out whether you're just going to go with an instinct about something, or whether you're going to think through it. Using your cognitive processes, you're going to think through it and arrive at the correct answer. But what if, and with a simple explanation, you're kind of like, oh yeah, okay, but you don't really care, right? So your brain is willing to accept that it's $1.05, and you're going to move on. You're not going to have a lot of conflict about the idea that your first answer of 10 cents was wrong. But what if I change the scenario a little bit? Family's dog car in front of their house. They heard dog meat was delicious, so they cut up the dog and ate it for dinner. How do you feel about that? Look, I saw this lady's face. She's like, ew, right? Gross. So now you're having an intuitive response and an emotional reaction. Ew, that's disgusting. What if I told you there was a shipwreck? The men had been stranded for 30 days on an island. There was no food. They barely had water. They hadn't eaten in 30 days. And so at some point, they turned to their beloved mascot, Spot. And they're like, Spot, it's time to go, right? And they decided to eat the dog. Now maybe you're like, okay, under that really bizarre scenario, I'm okay with eating the dog. You're still a little conflicted about it, right? It's not going to go down really well, but your deliberative process has now taken over your intuitive gut response, ew, that's gross, right? But you don't like it, you don't feel great about it, but you're willing to eat the dog just this one time. What are we doing in criminal cases? We're standing next to the guy who's charged with 77 counts of child pornography, right? We're standing up an opening statement and saying, that cop planted drugs on my client, right? We're telling the jury to eat the dog, right? Our first reaction is, oh yeah, that cop's a liar. Oh no, that guy didn't, that was an accident 77 times, right? But the jury is like, ew, right? So we are doing this every day. Oh, it took me a long time to find the right picture. Okay. Don't ever Google eat dog. I'm just a tip. All right. So, speaking of dogs, there are some. So the research tells us, the cognitive research about these cognitive reflection and intuition versus deliberative override, right? So what we're trying to do with our jurors is to get them over their initial reaction and to tell the right story to override their initial gut response of, ew, that's gross, right? Or, ooh, that guy's guilty, right? So how do we do that? Well, there's one concept called the identifiable victim effect. And this is a concept that comes out of advertising and marketing. And you can imagine a scenario where they show a dog who is, they're trying to raise money for the SPCA. They show a dog who is like a broken little leg or whatever. They're always in those little cute casts and stuff. And Sarah McLachlan is like singing to it. And that's one video. Another video, just statistics about how many injured dogs there are across the United States. And then in another video or advertisement, there's Sarah McLachlan singing to the dog with a scroll of all the numbers of dogs that are abandoned throughout the United States. Which one do you think gets more money from viewers? Just the story about the individual dog with Sarah McLachlan singing to it, right? So the story of one person is much more likely to kick us into deliberative override than a story or statistics or sort of broader strokes about a particular topic. So that's one thing the research tells us. One way to get people to override their intuition with deliberation is to tell stories. We can do that. We just learned how to do that. Another concept is this concept called anchoring. And what anchoring means is that people very early on will throw an anchor to an idea, and you can't really move them very far from it. So I hear lawyers a lot say things like, I'm going to save that for closing. Or I'm going to wait and tell the judge all the good facts when I'm doing my oral argument. Too late. Anchors are such an important concept in determining on how people will make a decision that you need to tell your audience as quickly as possible what it is you want from them and what it is you're going to try to convince them to believe. And we're going to talk about that a little bit more later. Words can also be anchors. So it's not just concepts that can be anchors, words can be anchors. I'll give you an example. This burger is 90% lean. This burger is 10% fat. People will pay 25% more for the former. right? Because of the way you are anchoring just the words, the way you're describing this, you're anchoring it to something that people are more likely to get behind. Right? And the final concept that we need to be aware of when we're thinking about communicating with jurors is the idea of cognitive dissonance.
The psychological story of decision-making doesn't end, however, when a decision has been made. The act of making a decision can trigger a flood of other processes. According to psychologist Leon Festinger, whenever we choose to do something that conflicts with our prior beliefs, feelings, or values, a state of cognitive dissonance is created in us, a tension between what we think and what we do. When this tension makes us uncomfortable enough, we're motivated to reduce it in a number of ways. We may change the way we think about the decision, or try to change how others think about it so that they can support our decision. Or we may change some aspect of our behavior so that our decision seems more in character with us. In other words, we try to reduce the dissonance between how we think we should act and how we actually act by changing one or the other.
And I apologize because this video looks like it was made in like 1970. It was made in 2006, so it wasn't that long ago, but it was like, wow, this is like health class all over again, right? But anyway, so this concept of cognitive dissonance, this idea that when somebody has very fixed beliefs about something, for example, people who have very strongly held beliefs that police officers are always righteous and tell the truth, right? It's going to be much, much harder. You're going to need a lot more deliberation. You need to do a lot more to make that deliberative process kick in, because at first, that person is going to reject anything that doesn't comport with their firmly held belief. So those three things, this idea of anchoring, this idea of getting the jury to connect with our client through telling individual stories, and the idea of immediately confronting dissonance when it comes up in our cases, when we have a credibility argument, for example. Those three things are really going to help us on our way as we're talking to juries. So what we want to do is open strong. We don't want to save things for closing argument. No more saving it, right? Unless it's that little nugget that they're really going to destroy in the state's going to be able to destroy in their case in chief. Like a couple little things for surprises at the end, sure, but not the whole story, not all the good stuff, and certainly not the anchor of what you're going to want the jury to believe. We want to use vocabulary and events as anchor points, and we want to explain to the jury and start to ease the dissonance right away so it doesn't become more fixed over time as the trial goes on. And I'm going to give you a little example of what I'm talking about in like a sample small part of an opening statement. Fuck this. Fuck this. That's what Andrew Crosby said to Officer Janot right after he complied with the officer's order to put his hands on the hood of a police car. You see, it was 1:13 in the morning. It was a couple of days before Christmas. The night was cold, the evening dark, the streets empty. And as Andrew Crosby crossed the street, police officer Janot saw him, assumed he was up to no good, and said, "Hey, you, hands on the hood." Assume position. And so Andrew Crosby did just that. He walked to the police car, he put one hand down, and then the other, spread his feet apart and hung his head down low. And there, in the cold and the dark and the stillness of that night, he said something. He said it in a voice somewhere between a regular speaking voice and a whisper. Fuck this. It was a stupid thing to say. It was inappropriate to say to a police officer under any circumstances. And it was the absolute worst thing that he could have said to that officer in that place on that night. But it is the only thing he did wrong that evening. He didn't have any drugs. He didn't resist arrest. He didn't assault the police officer. And you will know that not just because I'm saying it. You will know it because this officer tells the story differently each and every time he tells it. because this officer's testimony is unreasonable, and because this officer's testimony will be wholly unsupported and uncorroborated by any physical or forensic evidence. And at the end of this trial, I'm going to ask you to find under Crosby not guilty. Now, and we would continue. So what I'm hoping that you see is an example of an opening statement that's kind of designed to get at the things that we talked about. So it's emotional, right? It's certainly from the client's perspective. And you can imagine, I don't even have to tell you what the state's version of events is in this case, right? Right? He says, fuck this, that means he doesn't want to comply, and he punches the officer in the face, right? That's the state's version. So we're setting an anchor around the worst fact. We're taking control of fuck this, meaning frustration, rather than sort of a call to violence. And anchoring around that so that every time the jury hears it and sees it, that's what they're going to be hearing in their mind. And then the whole opening, so after that, we would talk about all the inconsistencies. We would talk about why the testimony is not reasonable. And then we would talk to the jury about the lack of physical and forensic evidence in the case. That's the whole opening. The whole opening is designed to get people past the dissonance that they may feel about now being told, another anchor, I'm going to ask you to say that this cop is lying, right? So that's like sort of an example of how at least you can use some of these concepts in talking to a jury. But what if you're not talking to a jury? What if you're talking to a judge? How do these things change, or do they change? So exciting research, again, I told you Chris Guthrie is doing very exciting work. One of his earliest studies was a study about, do judges and juries' brains operate the same way? Do judges have any sort of heightened powers of deliberation? Guess what? No, right? Judges are human. They think like the rest of us, and that means 95% of their decisions are made here. Scary. And when they gave them this test, they gave 200 judges the cognitive reflection test at a conference and told them that it was for something else. So they didn't know it was a brain test. 191 out of the 198 judges said 10 cents. And then moved on to the next question, right? Just like the rest of us. And this is something that gets us to this idea of blinking versus staring. You might have read that book, Blink. I forget the guy's name who wrote it now. Blinking versus staring, where those of us who were perfectly willing to say 10 cents and move on are blinking. Those of us who first said 10 cents and said, let me check my math and make sure that right, we're staring, right? Deliberation, think of it as staring. The initial gut response, think of it as blinking. So the question that a lot of these researchers were putting, and indeed the name of these studies, is blinking on the bench. Do judges blink on the bench, or are they more prone to staring? Certainly not more prone to staring. So what do we do with that? All of these things, all three of these things that we have already talked about, are at work with judges. All three of these things were found in the research. Judges experience all three of these things. But there are two extra barriers that we have to deal with, the brain research tells us, that we have to deal with when we're thinking about judges alone. One is something called hindsight bias, and the other is cognitive overload. The poor judges work very hard. Okay. I do want to step back to anchoring for a moment, though, because I cannot stress enough how critically important it is. And in Guthrie's work, one of the major conclusions that he makes is that anchoring has a profound impact on judges. Do not wait to tell judges what you want. Tell them boldly, and then give the reasons why you want it. And I'll give you an example from a sentencing argument, right? It was a case where I wanted a 10, the state wanted a 12. The very first thing in the sentencing argument is this. Defense is asking this court to sentence the defendant to 10 years in New Jersey State Prison. 10 years is a long time. And by the way, let's not talk about 10 years as an abstraction. He's going to go here. Here's a picture of where you're sending him for 10 years. That's what I'm asking you to do, and that's enough, right? So it's an anchor with a little support for why I want it. Now the judge is going to read my memo anchored at 10 and thinking, maybe that persuades me to go near 10. Maybe it persuades me to go to 11 or 12. I'm thinking about 20 anymore. Or so is the idea. And it worked in this case. He got much closer to that. And there's a million other examples about using anchors in written motions in a moment. So another concept that we want to be aware of is one called hindsight bias. And just as it sounds, hindsight bias means that we assume that the outcome of an event was predictable at the time the event occurred, right? Hindsight being 20/20 and all. And when the research done by Guthrie and others, there's other studies, a gentleman named Ahmed Jaber at Cornell University, there's some others, suggests that judges do experience hindsight bias. So from their lofty position on the bench or from our lofty position in the defense chair, we can think about what an officer maybe could have or should have done in the moment, right? And they've studied the effect of hindsight bias in criminal and civil cases. And what found in criminal cases I think is really interesting. It does not, shall we say, comport with my experience of being in court. What they did was they gave officers a scenario of a stop, of a search of a vehicle. And in one scenario, the judge knew that the vehicle would contain cocaine, and the other, they didn't. And they actually no difference in the outcomes of judges knowing that the car contained cocaine. However, this is what happens when psychologists write studies as opposed to lawyers. Because we don't know the amount. I would love to see a study. Maybe if I do get my chance to meet my idol, Chris Guthrie, I'll tell him, do a study on does it make a difference if it's 3 bags or 3 kilos? Does it make a difference if it's outcome determinative? If it means that this person is going to walk away free versus it means that a small piece of evidence in the case is going to be excluded, right? So the importance of the evidence and the amount of the evidence were actually not contemplated in this study. So to the extent that, at least I think anecdotally, I do it myself in cases where I'm saying, well, the officer should have done this and should have done that and should have done this. I think we should talk about it. Because there is an amount of armchair quarterbacking that goes on, particularly in motions to suppress, right? We all sit around saying, oh, when the suspect drew a gun, the officer should have done this and he should have done that, right? And we're not thinking about that moment. And the judges aren't thinking about that moment because they're thinking, yeah, and after this happened, somebody got shot. Or after this happened, they found 3 kilos of cocaine in the trunk. So how do we deal with that? I think one way that we can deal with it is through policies and procedures. You need to get in any kind of encounter between your client and the police, any policies and procedures that are relevant to that encounter. This way you can sort of mitigate hindsight bias by saying to the judge, we don't need to guess how somebody should have acted. That officer was trained on how to act in that situation. And what he did not comport with his training, did not comport with the policies and the procedures of that department. But we have to be really aggressive about moving for those policies and procedures in discovery so that we have them and we can question the officer about what he or she did or did not do in compliance with those procedures. Another thing is what I like to call the what's an officer to do test. And this comes from, when I was a law clerk, I worked for a phenomenal judge named Judge McAvoy in Massachusetts. And she used to always say to me, because I would come in and want to suppress everything, and she would always say to me, but what was the officer to do? Let's think about what would the officer to do in that situation. And it was those situations where I was like, I don't know what he did, right? That would be where the evidence wouldn't get suppressed. But if we could spin out all sorts of other things that the officer could have done that would have been more respectful of our client's constitutional rights, then it might be, hey, maybe we need to suppress here, right? So the old what's an officer to do, and you can write that in a motion. Judge, the court may be asking, what was an officer to do in this situation? I'll tell you. The procedures will tell you. The law tells you, right? You can make that part of your motion. The other thing that you can do is really simple, and I'll tell you, I don't know, is Norm here? Yeah, okay. So Norm Raymer, who's obviously the executive director of NACDL, I haven't seen him yet today, talks a lot about the trial tax and the trial penalty and has done some phenomenal work over the last couple of years on that. And we all know there's a trial tax. We all know judges do it. And he had the amazing idea of just telling them that. And I was like, wow, why don't we just tell judges what they're doing? And I think with hindsight bias, as with other forms of bias, What bias training kind of teaches us is that the first step in confronting bias is admitting that it exists. So one thing you can do to judges is just remind them, don't have hindsight bias. So this is from Emotion. This is a gun in a murder case. There's perhaps no type of crime or case in which the stakes are higher. Defendant would be a fool not to acknowledge the weight of the court's task. The Fourth Amendment, however, compels the court to look not to the magnitude of the result, but to the search alone. And then it goes on to sort of guilt the judge into not using hindsight bias to decide this case. All right, so cognitive overload. Cognitive overload, just as it sounds, means your brain just can't handle everything that's going on. Judges are extremely prone to cognitive overload because they're very busy. Mood has a profound effect on judgment. We all know that in our own lives. Positive moods are deliberation. The better mood, the more likely they are to think about what they're doing. Conversely, if they're in a bad mood, they are less likely to think and more likely to react from their gut. I love this line from the study about judicial intuition. We are not adopting a bizarre suggestion here administering Prozac to unhappy judges. But what we're saying is there really is a problem if a judge had a fight with her husband before sentencing your client. That will impact the sentence that is given. It is human nature. And there's not much that we can do about it, but there are some things that we can do about it as lawyers. And there are a number of sources of cognitive overload. And the one that is chief among judges, the number one source of cognitive overload, may surprise you. In-court objections. The leading cause of cognitive overload are in-court objections during jury trials. Because think about it. There's the judge on the bench, may or may not be paying attention. There's a legal issue that comes up. Both sides have a very strong position. The judge has to decide right in that moment, and there's an audience, right? That's a lot of cognitive stuff going on. So what can we do to sort of ease cognitive overload? So as part of our job is to try to figure out ways to ease this for judges and give them the cognitive shortcuts, but not the cognitive shortcuts that are going to work against us, to induce the cognitive shortcuts that are going to help us get the result we want. So one is consider motions in limine over trial objections. And obviously there may be strategic reasons that you hold something, but to the extent that you think the judge is really going to need to think about it, maybe that's the time you do a motion in lim as opposed to making the objection mid-trial. Scheduling. If you have control of the schedule and you know judge is cranky in the morning, or the judge likes to have a big lunch and is sometimes sleepy after lunch, right? If you can schedule around that, it really is a thing. Judicial training. There probably should be more training of judges on how their own emotions and how their own circumstances affect that, but there's not much we can do. But if you are in a position where you are responsible for any judicial training, this might be an area that you start talking about. And then finally, one thing that we can really do is leverage our written advocacy. If it's in writing, the judge doesn't have to look at it after she fights with her husband. If it's in writing, the judge can pick it up and spend a long time reading the stuff that he doesn't understand. If it's in writing, the judge can look at it whenever he wants. But if you're going to do that, your writing has to not only be interesting, it not only has to be done in story form, it also has to provide the judge with some of these cognitive shortcuts that we're talking about. So how do we do that? You know, when I first kind of started doing more teaching, I was really into teaching trial advocacy because I thought trial was everything, like how we do trials and standing in front of juries and that whole jam. But over the years, I have started to fundamentally believe that written advocacy is what makes or breaks cases. Because usually documents submitting to courts in writing is our earliest opportunity to start persuading. So just like we talked about with juries, where you're not going to save it for closing, don't phone in these written things and say, well, I'll just dazzle them with my cross-examination at the motion to suppress. It's too late. Put your arguments in writing. Use all of the skills that you know as an oral advocate to write your written motions. And we'll talk about how you do that. And this is an article that was recently published in the American Bar Association magazine, where they talked to judges about what they're looking for in written advocacy. And they said, shoot for strong, compelling, yet concise introductions, a restrained use of case law, and modern diction. What are they telling you? Tell us stories, be concise, and stop putting all those string cites in, they bore me. Right? That's what they're telling you. I think it was Justice Kennedy who said, I've never read a brief I couldn't put down. Give them a brief that you can't put down, right? That's what we're looking to do. So how do we do that? Well, we want to begin with what's most important to the story, not what happens chronologically. The second you start in chronological order, you're just going to put people to sleep. So you want to start where it's most important. You want to start at that moment where the search goes bad for the state, because that is where you're throwing your anchor. That's the moment you want the judge to talk about, and you want to talk about that in very vivid detail. And again, you want to apply all your trial advocacy skills. None of this, at such and such a date and time, John Smith walked across the street, and then like, just parroting back the police report. Tell the story the way you want to tell it, using facts just the way you would write an opening statement. So this is a sample of a beginning of a motion that I think does some of this. Get out, keep your hands up back here, come all the way back here, indicating the rear of the Nissan. Put your hands up, indicating the hoods of the Nissan. Those are the orders from Officer Cook to Michael King before the officer asks him a single question about what the state purports to be a motor vehicle stop. By the time the officer does ask, King has already been instructed to assume the position, feet spread apart, back to Officer Cook, Officer Wisman's flashlight shining in his eyes, hands on the hood of the Nissan. That's what I need the judge to think about. That is my anchor. That is where the stop goes bad. I don't need him thinking about the gun that was found in the car, right? I need to put him here very vividly and very strongly. Okay. And you need to kind of hit all of these things in your written advocacy. So one way to do that is through the use of visuals. Visuals are cognitive shortcuts, right? The whole idea that a picture is worth 1,000 words, we're talking about a cognitive shortcut, right? If I can show you a picture rather than give you a lot of facts to explain something, I'm shorting your cognition and making it easier for you to understand my position. And I guarantee you the prosecutor's not doing this. So you're being helpful to the court. So what does this look like? So this is a motion to suppress. You can't read it. You don't need to read it. I just want you to kind of look at it. And we're going to talk about some parts of it and using cognitive shortcuts to help the judge get to where you want to go as opposed to your adversary. So here's one. There's 1 minute in this case, 1 minute from the MVR that really makes or breaks the case. Think about what you would have to do if you didn't put that little video clip right in the motion. The judge would have to read that, find the disc that was admitted into evidence, insert said disc into some sort of reader, find the spot in the MVR where that happens, and then watch it. What are the chances you think any of that would happen while the judge is reading your motion? None. But what if you took that 1 minute, put it in there, said, Judge, click here. And he can watch it. And you would make sure you attach a thumb drive in case it doesn't work on his computer, and he can put in a thumb drive and double click it and watch it. You've just made actual shortcuts, not just cognitive shortcuts, but then you're also making the cognitive shortcut, this is really important, and this is all I need to know. Pictures. This is 5 pictures admitted into evidence that were stitched together to show what it would have looked like when this young woman was sitting in a police car, what she could see in front of her, and what she could see behind her. Again, the judge doesn't have to pull these photos from evidence. He doesn't have to put them next to one another, put them in the right order. It's there, it's done. And then charts, timelines, anything like that, right? So I needed the judge to believe my timeline. So the last thing I wanted him to do was keep watching the video. So I made a chart that shows where it is. If he does want to watch it, he can go see it. But this is the narrative I want. These are the things I want pointed out in the video. And I highly doubt the judge was watching the video, especially after he had this. Right? So these are ways to, within your written motion practice, to make it easy for the reader to sort of get to your point of view. And one thing you do want to ask judges, I've gotten in the habit more recently with the advent of tablets and more mobile computing, of just saying to judges, Judge, how do you like to read your motions? Are you more likely to read it on the computer or do you print it out? Because if I'm going to do that motion, I want to print it out in color if I know he's a printer kind of guy. If I know my judge is a tablet kind of gal, I'm going to want to make sure the pictures are a little bit bigger, and I want to make sure that I underuse footnotes, because everybody who has a tablet knows it's a huge pain in the butt when you're going back and forth to footnotes, right? So you want to make it really easy for the judge to take it in, but you need to know these things. And when in doubt, give them both. Give them a printed copy, especially with this e-courts thing. Oh, I hate it. I always file stuff on e-courts, and then I send a note saying, don't read what I filed on e-courts, I'm bringing it to you. And bring them a copy of what I want them to say. All right, so very briefly, I want to talk a little bit about police officers. I'm checking time. Perfect. Very briefly, I want to talk about police officers, and then we're going to talk a little bit about expert witnesses. So police officers are interesting. It's a stupid thing to say. Police officers are interesting because we have two things that we're sort of working with when it comes to looking at psychology, looking at research, and looking at the way we approach them. One is, how are police officers trained to think? How do police officers operate? And what does that tell us about the way we might be able to structure questions to get further with our officers when we have them on the stand? The other piece of this is, what do our jurors think about police officers? There's a very high sort of hurdle that we have, because unlike us, who are perfectly willing to eat dog, most people say, oh, police officers, I love them. As a matter of fact, there was a recent Gallup poll that suggests that police confidence in the police is back to nearing all-time highs. And we're talking about, when we look at these numbers, I'll tell you why, and probably not a surprise. African-American confidence in the police maintains at about 35%. It's pretty static. Hispanic-American confidence in the police is kind of plummeting. Guess what's moving up so fast that it's making up for the difference? White confidence in police. That's what's making up for the uptick in that number. So, and I don't know about you, I don't know what your juries typically look like. I find that I do have more predominantly white juries in New Jersey, depending on where I'm working. But regardless of that, taking the race of our jurors out of it, we know from this that 7 out of 12 of our jurors walk into the jury box ready to believe the police. So we have to be prepared to induce the deliberation to overcome that intuition, and to aid those people, our five people, to aid our 5 people who don't necessarily come in with preconceived notions about police, to aid them in helping convince the others. So we have to get them to eat dog and to dress up the dog, really, really well and make it really, really appetizing. And you're about to see my favorite slide in this presentation, so you better laugh. Get it? Let it kick in. We're talking about police. The dog dressed like a come on. All right, I liked it. It amused me, and it took me a long time to find it, so appreciate it. No, I'm kidding. So how do we make them eat dog when it comes to police cases? How do we get them to say, I love officers, but this one officer is a bad apple? Right? Okay. So one thing we want to think about is we can take some tips from how police officers actually think, how they're trained to think, and what their psychology is all about. So there's something called priming behavior with the police officers. And this is being studied. It's being studied at the University of Albany by actually a man who has a master's degree. He's formerly a police officer, and he's doing a lot of these studies on officers' expectations about the presence of absence of factors and how that informs their responses in the field. And what they found is, when presented with very little information, with fragments of information, they are much more likely to rely upon heuristics, to rely upon their gut, to rely upon their instincts, right? And the case I gave you earlier is a perfect example. Young man, 1:13 in the morning, walking around the street in the wrong part of town, must be up to no good because the officer doesn't have any information to convince him otherwise, right? And that their information that they get is informed by a number of sources, right? By dispatch, by roll call, by crime statistics, by everything they're telling them every morning or every night before they hit the streets to do good, right? So there's a really interesting study. It's recent too. It's 2016. And I will tell you, it's a study where this gentleman, Paul Taylor, I think he's a social worker, Paul Taylor, did this study where there were two scenarios, one in which the police officer was given, actually three. One in which the police officer was given information that the suspect had a gun, one in which they were given information that the suspect had a cell phone, and one in which they were given none of that information. Now, as an aside, I Googled gun and cell phone thinking that there was going to be a picture maybe of somebody holding a gun in one hand and a cell phone in the other. You know, you never know. You Google stuff, you don't know what's going to happen. And I got this, which is the most messed up cell phone case I have ever seen. Can you imagine? Like, please, like, as a PSA, do not buy this cell phone case because somebody will kill you, right? That's crazy. But anyway, so this is a cell phone case. So what the study showed was this. 62% of the officers that were told in advance that the suspect had a gun shot. And it was in one of those scenarios, you know, those computer scenarios where they go in the computer and it's, will you shoot or will you not shoot? It was not out in the field. It was one of those computer things. So 62% of the people of the cops who were told that the suspect had a gun actually used their weapon at the scene. 28% of the control group fired their weapon. And I will tell you that the scenario itself did sort of like put you in a situation where you probably would have to fire. But here's the really surprising thing, I thought. Only 6% of the officers that were told that the person had a cell phone fired. So less than the control group. And it tells you a little bit about the power of information. The power that the information that cops are being given on dispatch, at roll call, before they go out in the field, and how that impacts their decision making. So what do? How can you use that? Well, you can sort of flip the script on them. So if we take my example earlier of the young man crossing the street and getting harassed by the police, there's a whole bunch of chapters that you can do with this officer about what he was told at roll call. In Newark, they do something called proactive patrol, which means go out and look for crime. That's a thing, right? Proactive patrol. So if you ask a police officer, and they're proud of this because every morning they tell them, you're on proactive patrol. So if you do this line of cross with the officer, you were on proactive patrol. That means you're not just sitting there. You're out there looking for crime. You are looking, and they're like, yeah, right? Because they're primed. This is what they are primed to do. And then you could talk about high crime area. Their eyes light up again, right? Because in this case, he said that my client had drugs next to him. So we want high crime area. We love high crime area. There might be drugs laying around this area, right? So all these things that they're repeatedly told in their roll call that become sort of part of their own scripts, you can use, and you'll have a very easy line of cross-examination with the cop. And then in your closing argument, of course, what's the closing argument? He's out looking for crime. It's 1 o'clock in the morning. It's a high crime area. There's drugs all over the place. Of course he thinks this guy has drugs, right? So you can turn it on them later. But just kind of playing into that psychology a little bit could be really helpful for you in certain kinds of cases. You want to think about officer bias, and remember that bias is a story. And what I mean by that is you always have to identify the reason why a police officer is acting the way they are. It's not good enough that they're a cop and they're aligned with the state. And there are a whole host of reasons why an officer might be biased. And what I think, I'm not going to go through all these. You know this. You can tease this stuff out. The one thing I want to say is that we have to, as defense attorneys, again, we're really willing to eat the dog right away. We have to start to think, is there a way that I can make this officer right? That I can make this officer righteous but still wrong in this situation? So bias doesn't always have to be negative. It can be positive. It can be that this person recently got a promotion. It can be that they're brand new and they want to do a good job. It could be that they're about to retire, right? All of those things are biases, but they may not be negative. So we had to think about bias from think of it more like motive and less like actual bias. One thing really quickly on police officers, you want to group impeachments. You want to do all your impeachments with a police officer at once. Don't save them for the relevant moment in your cross-examination. And that goes back to the cognitive dissonance again, right? I was doing a motion not that long ago, and I had like 12 impeachments for the cop. So I started with number 1, and I was going to do all 12. After the first one, the judge, who was very participatory, let's put it that way. After the first one, the judge was like, oh, well, it was rapidly unfolding. Thanks, Judge. After the next one, oh, well, there's a lot going on. After the next one, we got to like 5 or 6, and then I looked at him, and he goes, I got nothing, right? Because people who have that dissonance are willing to excuse the first couple. But after a while, it's like, now it's starting to sound suspicious. I can't forgive you anymore. So think about grouping things in that way. I want to just lastly, very quickly, talk for a few slides, I think I'll be perfect timing, on expert witnesses. I was really happy to hear this morning's presenters talking about credibility, because really the net of the studies on expert testimony is that jurors first make a decision about the credibility, the believability of the expert, and then filter what they're hearing through that. Different from attorneys. That is actually not true of attorneys. And then we have high cognition learners and low cognition learners, so people who need to process things versus people who don't. So when it comes to expert witnesses, high cognition jurors are persuaded more by the substance of their testimony. Low cognition jurors are persuaded more by their credentials. But both, regardless of whether they are high cognition or low cognition jurors, the first thing both of those groups do is assess the credibility. And I don't mean by their credentials. I mean by, are they looking me in the eye? Are they nice? Are they talking to me? Can I follow them? Right? So this tells us that when we're dealing with experts, well, first of all, when we're dealing with experts, you're probably better off going without them. And the reason for that is there are several studies that suggest that when it comes to defense cases, they just believe that these experts are going to say anything that the defense attorneys want, regardless of how much they like them. So you are probably far better off working with your experts to prepare the cross-examination and then leaving the expert at home for the actual trial. But if you can't do that, you want to make sure that you frame the evidence as a story so that the expert isn't sort of some aside to the story or a pause in the action. The expert becomes part of the action in the story. You want to work with them on style as well as substance and learn that shorter is better. And use visual aids, not PowerPoint. Because if there's a PowerPoint that has a lot of words on it, it's going to take the jurors away from making that connection, that credibility connection with the expert that we know is so important. So if I had another hour, what we would talk about now is storytelling in the brain and how storytelling comes into play. But really what I wanted you to get from this, and I'm hoping that you took away a couple of things that you might be able to use as you start thinking about what happens before story. One of the things I love about NACDL and why I always feel so privileged to be here with all of you and to have the honor of being able to give presentation every now and then is that it's sort of a petri dish for new ideas that we can experiment with. So I'm asking you now to challenge yourselves to think even further beyond story and think a little bit more about the brain.